Of Washington Legal Foundation's Legally Brief, Matthew Bathen, a patent litigation associate with the law firm Arnold & Porter, will address the growing phenomenon of patent marking litigation and an important Federal Circuit ruling on that.
In December 2009, the Federal Circuit determined that the penalty for falsely marking an item as patented must be assessed for each item that is falsely marked. This was a significant departure from the prevailing view of the false marking statute, which held that the fine should be imposed for each decision to falsely mark. In Forest Group v. Bond Tool Company, the Federal Circuit noted that 35 U.S.C. Section 292 permits a fine of not more than $500 for each offense of false marking, and it is up to the court to strike the proper balance between encouraging accurate patent marking with the risk of imposing large penalties for inexpensive, mass-produced items. The Forest Group decision brought about a wave of false marking lawsuits. Many of these cases have been brought by individuals seeking a significant windfall from manufacturers under the newly invigorated statutory penalty. The Federal Circuit has already issued a second opinion regarding false marking, and another decision is expected later this year. And these decisions offer some guidance to companies facing the prospect of defending against false marking claims. On June 10th, the Federal Circuit decided Picaneau v. Solo Cup Company. Mr. Picaneau, a licensed patent attorney, sued Solo Cup for falsely marking its drink cup lids with patents that had expired. The court held that an item marked with an expired patent number is unpatented within the meaning of Section 292, but the plaintiff must still establish that the marking was done with the intent to deceive. While false marking with knowledge of the falsity gives rise to a presumption of intent to deceive, that presumption may be rebutted. In Picaneau, the court concluded that Solo Cup had rebutted the presumption of intent to deceive by demonstrating that it had relied on advice of counsel and had continued to market its products with expired patent numbers based on legitimate business decisions to reduce costs and avoid manufacturing interruptions. Few, if any, of the new false marking lawsuits have been brought by actual competitors who might have suffered an actual injury by a defendant's false marking acts. The Federal Circuit will address this issue in a currently pending case, Stouffer v. Brooks Brothers. The district court dismissed Mr. Stouffer's case, finding that he lacked Article III standing because he had failed to provide evidence of actual harm to himself, other consumers, or the government due to the defendant's acts of false marking. While Section 292 provides that any person may sue for the penalty, the district court would not permit Mr. Stouffer to proceed without some injury in fact. A decision by the Federal Circuit regarding what injury must be established and who may assert that injury to bring a case for claim of false marking is expected later this year. In the meantime, new false marking cases continue to be filed, and the law in this closely watched area will continue to develop.
Mr. Bathen and two of his partners have drafted a legal backgrounder for Washington Legal Foundation, which will be released next month.